in.
One of them is from our 2:30.
Okay.
So I'm gonna let everybody. Do you want me to let her in too, or just keep her?
Everybody in. Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Hi, Diane.
Hi, Seth. How are you?
Very well, very well.
All right. Do we have a set of any case yet or no? Two people here on any particular case?
Oh, Judge, it looks like I have my counterpart. I'm here for Discover Bank for plaintiff, Discover Bank versus Emily Primo.
Okay, thank you. The court will call the case of Discover Bank versus Emily Primo, case number 21C 1148.
Honor, my appearance, Seth Goldner of Counsel of Buckles and Buckles on behalf of the plaintiff.
Thank you.
Diane Xagoraris appearing on behalf of the defendant, Emily Primo, P32106.
Hello, counselors. It's nice to meet you both. Today is the day and time that's scheduled for motions for summary disposition as well as for a pretrial conference. I do have in my file here a motion for summary disposition and for judgment, which was filed by the plaintiff, but I don't see a response.
That's because the response was not filed. I have been talking to the defendant and been talking to my client, and at this time we would concur with entry of the motion.
Thank you.
Judge, I guess my position is pretty clear, which is that we would agree that we should enter a judgment against the defendant by motion or by consent if counsel is authorized. Your Honor, let me ask you a question. Do you happen to have a copy of the proposed judgment and the notification of non-military status certification in your file?
I have a copy of the order of judgment, and yes, it also has the, let's see.
I think they call it the certification of non-military status or non-active
I
status.
don't have that. I just have, all right, this document that I have is this judgment, civil judgment, and the order of judgment. It says there's a asterisk. It says for a defendant on active military duty, default judgment shall not be entered except as provided by the Civil Service Relief Act. And I don't have the other part that says they're not on active military duty.
I do have that document in my possession. There's some way I might share it or make it or send it to everybody by email real quick.
You can send it by email.
Well, it sounds like that's what I should be doing right now.
Why don't you send it to the court through their general landlord-tenant email address? I'm sorry, it is 14B civil. Do you have that already, sir?
I do not, but I'm writing it down.
And then it's a hyphen landlord-tenant at washtenaw.org.
Tenant at Washtenaw. I'm going to read that back just to make sure I'm correct or clear on it. Your Honor, it's 14B civil, 14 letter B, then civil dash landlord tenant at.
All one word.
What's that?
All one word, landlord tenant.
Yep, that's correct. Landlord tenant at washtenaw.org.
That's correct.
Your Honor, if you can just give me a moment to get my copy of this document in an email so I can email it to you. I'll be happy to send it right now, or is that just something the court wants to see before it enters the order?
No, I don't need to see it before I enter the order. Just file it right now so that we can have it in our file.
Okay, Your Honor, thank you. Do you want me to do that after we're done with our hearing then?
As long as you, I prefer you do it right now. And
Oh.
then that way it's taken care of. But I am signing the judgment based on the defense counsel. How do you pronounce it? Agaris?
Zacharias.
Zacharias.
Pretend the X is a Z. That works the best.
Representations here today. I'm signing this order on July 29th, 2021. And it, just so that you know, Ms. Zacharias, it says that the entry of the judgment is for $75 for filing costs. Motion for 20 service fees of $35.20 for a total cost of $130 plus the original avert amount of $3,588.81 for a total of $3,709. And then they have checked the box here and they have entered no interest rate, no interest at this time, but that short rate they have in here is 13%. And I'm signing the document.
Thank you. I'd just like to state for the record that our client always voluntarily waives the statutory attorney fee and any prejudgment interest from the date of filing. So that is a correct recitation. I'm just letting you know it is on purpose, and that's exactly, you know, it's a policy. If I can have another moment here, I'm about ready to let this email do its thing. And Diane, can I also email this to you at this moment?
Sure can. Do you have email?
Is it the one that ends at getmeadlaw?
Yes, that's it.
Okay. Well, then I think we're all set here. You'll both get this in just a moment.
Thank you. Thank you. Nice meeting you both.
Oh, Judge, thank you so much. I appreciate it.
Bye-bye.
Thank you, Judge.
Mr. or Mrs. Navjoy Francis.
Judge, can you hear me?
I can now.
Judge, can you hear me?
I can now. Yes, I can. Can you hear me?
Can I try to fix my audio? I can't hear anything.
Yes, you may. I know you can't hear me say that if you can't hear anything, but yes, you may.
Judge, real quick, Seth Goldner, I sent the email. Do you want me to log off now?
Yes, you can log off. Thank you,
All
Mr. Goldner. Nice
Good.
meeting
Thank
you.
you. You too. Thank you.
Thank you.
Appreciate it. Hi, Navjot.
Bye-bye.
Bye-bye.
I don't know. Miss Francis could be here. Ms. Gordon, your matter is scheduled for 2:30, just so you know.
Okay, thank you.
You're welcome.
Judge, if you can hear me, I'm gonna try to reconnect. I don't think it's working.
Okay, thank you. I can hear you.
Just wanted to make sure it was all working now.
I'm waiting for my recorder to return before we can resume court, so it'll be just one moment.
Thank you. It's so nice to hear you, Judge.
Thank you.
My
That's good, because you couldn't hear a thing before, huh?
computer, the internet went out, and so I was trying to do it from my cell phone, but I guess my Wi-Fi in my office isn't
Yes.
connecting me. I don't know. So I was like panicking.
Gotcha. No, it's okay. I was
I was
telling
just
you,
hoping you could hear me.
I could hear you, and I was telling you, yes, it's okay.
Oh, you're muted now.
Yes, I was saying, but you probably couldn't hear me when I was responding to you, so it didn't matter. All right. We're recording again. The 14B District Court is now back in session. My name is Elaine Washington, and I will be the judge that is continuing this session. All right. Ms. Francis, which matter are you on, please?
I have LVNV funding versus Veronica Lydell.
Thank you. What we'll call the case of LVNV Funding LLC versus Veronica Liddell, case number 21C0491.
Good morning, good afternoon, Your Honor. Navjot Francis on behalf of plaintiff's attorney of record P72322.
Good afternoon. So we're here on this matter for entry of order. It was my understanding that the parties had reached a resolution when they were in court on July 1st. And that there was going to be an order for dismissal, conditional order of dismissal that was going to be filed.
Yes, Judge. We did send the defendant the conditional dismissal on July 2nd. However, the defendant has not sent it back to us, so we have been unable to file it with the court. She did agree, I believe, to my understanding on the record of this conditional dismissal with the payments. However, we just have not been able to get it signed.
She did agree on the record with that, and I was thinking that this was going to be set. You can send it under the 7-day rule, and then that way we don't have to be concerned about whether she actually signs.
Okay. We will submit that under the 7-day rule.
Thank you. I will reschedule this for another entry of order date just to track it to make sure that it is submitted. No, let's make sure. No, try the 19th then. That is bad. Oh, yeah, the 19th. Beautiful. 2:30 on the 19th. August 19th, 2021 at 2:30 p.m.
Thank you, Judge. Have
Thank
a good afternoon. And thank you.
Better afternoon.
Thank you.
Court will call the case of JGA Acquisitions, Inc. versus Charnita Gordon, case number 21C0582.
Good afternoon, Your Honor. My name is Kerry Stanfield, P78102. I'm with Velo Law Office, and we represent the plaintiff, JGA Acquisitions, Inc. in this matter.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. Are you Ms. Charnita Gordon?
Yes, ma'am.
All right, thank you. We're here today for a final pretrial as well as a motion by the plaintiff for summary disposition. A motion for summary disposition is a motion that says that this is why the plaintiff should win their case. And have you received that motion?
I received it.
All right, thank you. All right, this is your motion. Mr. Statfield, you may begin.
Thank you, Your Honor. Um, just to make matters simple, let me go through the summons and complaint was filed on January 15th of 2021. The defendant filed her answer on March 30th, 2021. Plaintiff has propounded on the defendant its discovery consisting of first set of interrogatories, request for admissions, and request for production of documents, and that was done on May 4th, 2021. The defendant has failed to respond to those discovery, namely the request for admissions. And based upon the defendant entered into a written lease for a period of 1 year commencing on January 1, 2018 and ending on December 31st, 2018. The defendant vacated the property, I believe, in November of 2018. And she did not pay November's rent nor December's rent. She vacated the property, I believe, on November 7th, 2018. So she owes for 2 months rent, and rent is $755 per month. She received a credit of $500 for her security deposit. And there's a termination charge, which she acknowledged in her notice that she was vacating the property early, which is, I believe, as Exhibit 4 to our motion, which she acknowledged that $500 fee. So there's a current balance owing for rent and utility charges totaling $1,307.33. Due to the fact that she has failed to respond to the request for admissions, those are deemed admitted. And so in essence, she has admitted not paying and owing this said sum. And we believe that, that the pleadings before the court clearly established that as a matter of law, we're entitled to a judgment, as there is no material dispute to the liability, nor to the numbers, nor to the amount owing under this claim.
Thank you. Ms. Gordon, so there are a couple things that I want you to understand before you begin to make your statement. One of those is when requests to admits are sent and there is no response to them by court rule, they're deemed admitted. So everything that is in those requests to admits that were sent to you, you are deemed to have admitted that, and that becomes a part of the evidence that's in this particular file. Do you understand that piece, ma'am?
I do now, but I didn't.
Yeah, that's how that works. So do you have those requests to admits, and you know what they are acknowledged?
The magistrate, previously I explained to him that on the discovery on some of those questions was asked about a buyout contract, which they still have yet not been able to send me, stating that they don't have it, but on some of the questions it's inquiring about it. So I can't answer questions with something that I just have a photocopy of and you telling me that you don't have it in your possession. That's the confusion, which me and the leasing and the apartment complex know that I was in a buyout contract. So which means I could have left it as long as I give them a proper 30-day notice, that I could have left out of my contract. And like I said, they still have yet to give me those documents.
Indicate that you took a picture of this buyout contract?
I did. I took a picture and I did provide you guys with a picture in my answers. But that's just a picture of basically the name of where I was staying, and you see it says buyout contract and my signature. But that's all that I have. I was told that I would receive it. I never received it. They gave me to run around while I was still in my contract. And so I don't know where the document is.
Your Honor, may I say something?
Yes, I was going to ask you a question anyway, sir.
You want to ask me your question first? You want to?
Let's start with that. In your request to admit, which I've explained to Ms. Gordon that they deemed admitted. Sorry, I'm trying to get back there. I was reading her a separate document that she had submitted. Now I'm trying to get back to the request. All right. In your request for admissions on number 9 and 10, number 9, for instance. If it is your position that you were provided a buyout contract, please admit that you provided a 60-day written notice of your intention to vacate the property on October 17, 2018. Can you explain to me how that helps your case?
Well, we're just trying to determine what her position is. What I was going to say, Your Honor, is under paragraph 4 of the buyout agreement, it says you may buy out the lease contract prior to the end of the lease term and cut off all liability by paying rent for the remainder of the lease term. Now, I'm not quite sure. I mean, that's telling me that she remains liable for her contract for the 12 months of rent. I see where there's a buyout fee of $500. And I'm not sure she ever paid that fee. We don't, I don't believe my client shows a record of that buyout fee, which is what's called under F4, paragraph 4 to that buyout agreement. I'm presuming you have a copy, so you see what I'm reading.
I do.
I'm just suggesting that even if there was a buyout agreement, she still remained liable for the 12 months of rent that she originally.
I don't understand this type of a buyout contract. How does one buy out of a contract and still owe for the remainder of their lease? And in addition to that, how do you in fact not mitigate any of your damages?
Our damages, well, I'm not sure there's any damages to mitigate. We're not claiming, I mean, we're only claiming unpaid rent for November and December, plus the utilities for one of those months that she remains liable for.
That's my point, though. Let's say, for instance, under this agreement that you have here, if a tenant decided that they wanted to try to use your buyout procedure, and they said that let's say their lease is from January to December, and they give you your 60-day notice as is required here. And it's, say, April. Are you saying they owe you for May, June, July, August, September, October, November, December?
Yes.
All right, that's not the way the law works. This lease is in violation of the law. You have a duty to mitigate your damages by reletting the property.
I understand that, but in this particular case, I don't know if they tried and they couldn't re-rent it or not. I mean, we're talking about 2 months rent. I mean, under your example, Your Honor, I would certainly agree that there may be sufficient time to re-rent the unit given 4, 5, 6, 7 months. In this particular case, she vacated in, we claim that she vacated in November, so she still owed for November's rent, and she didn't pay for December's rent when her contract expired.
Thank you, Counselor. Ma'am,
Yes, ma'am.
in with respect to you and this lease, it says here that you must give notice, 60 days notice, and it must be the last day of the month. And paragraph 4A of this buyout agreement.
Mhm.
What,
I'm not, Your Honor, I'm not disputing that there is some money owed, just not 1,300 plus court cost fees.
all right, so it
So-
says here that, let me finish for a second. It says here that the date and time of this buyout agreement was November 30th. So you owe them for the month of November.
Yes,
Okay. And you owe them the $500 fee. Unless you're trying to tell me you gave them a different, no, did you give them a check for the $500 fee?
well, no, I didn't give them a check for the $500 fee.
So you owe them $500 fee if you were even doing a buyout, if that were something that you two
Right.
could agree
So
on.
my
We're
thing
not
is
there. I'm
that-
just trying to understand. Okay.
Right. So my deposit. So if it's the month of November plus the $500, he's saying that it was $755. That is $1,255, correct? So my deposit was $500. Now utilities, I pay my own water and electricity, DTE. So it was two different. I had DTE and then I had water I paid for. So when he says utilities, he's talking about sewage and like trash. That's it. So what is the fees for that? If you took my deposit of $500.
Well, your 500 deposit would have gone towards the buyout agreement. At a
Right.
minimum.
So that's what I'm saying to you. So if that went towards, which I was told that it couldn't be used towards that,
Okay. So you
even though they
understood
have
that.
no recollection.
You
Yeah, even
understood
though they
that.
had no recollection of the buyout contract. We're talking about something they can't give me so that we can really look at the document fully, you know. So like I said, I'm not disputing that, but what I'm disputing is me not owing that full amount. And then I was going to take a loss with paying the $1,300 because this isn't my expertise. And as you can see, with the discovery and me not being efficient with my responses. But then, you know, the last court date with the magistrate, she, you know, I guess an associate from the firm was like, well, you have to pay the fees as well. And I'm like, listen, I'm already taking a loss when I know that what I'm saying is correct. That was the whole point of me going into this lease again. I would have just did month to month. So I'm not saying this just to say it. Like I'm not, you know, trying to get over anything. I'm being honest from my, you know, from what I was told. So, and the contract that I had signed. So like I said, I'm not saying that I don't owe anything, but it's just the amount and then them, I guess, playing hardball, trying to get me to pay for the fees. And it's a lot. And financially, I am not in a position. And I explained that to them. And this is why we're here now.
All right, well, so what's before the court today is a motion for summary disposition, and you have not responded to the request to admit, which are then therefore deemed admitted. The unfortunate
Mhm.
part is I asked brother counsel here about number 9, but then what happens is I didn't ask him about number 10, which directly goes against you. Number 10 is, if it is your position that you were provided a buyout contract, please admit that you did not make the payment of the $500. So that's deemed admitted, okay?
Mhm.
So it also is deemed admitted that you have unpaid utility charges for water, trash, and sewer from June of 2018 through December of 2018. And it's
No,
deemed,
Your Honor.
okay, well, unfortunately, it's deemed admitted because you didn't
Mhm.
respond. That's why it's difficult for pro per people who don't have counsel to.
And exactly. So, and by them knowing that, that's a disadvantage. Knowing that, like I said, this isn't my expertise, knowing that I don't know anything about law. You understand what I'm saying? From this perspective, they, you know, I'm in a bad position, you know, so.
Mr. Statfield, what
Yes,
is
Your
the
Honor.
amount of utilities that you're claiming are unpaid?
I believe it's $283.33. $283.20.
And what time frame are you claiming that those were based on, please, sir?
I believe it's from June through December of 2018.
So you're saying she didn't pay any of the trash or sewer from that time period to, from June of 2018 until December of 18?
Yes.
Is there a ledger that was provided to you? And I think this is a debt that was sold, is that correct?
I believe you're correct. I'm trying to see when that sale. Our brief does not indicate it. To answer your question, I don't know when it was sold. I'm looking at our brief, which I did not prepare, but it seemed it indicates that the original creditor, Woodcrest Group LLC, was owed this $1307.33, and then it was assigned to the plaintiff.
I understand.
So we do have a ledger, which I believe is attached to as Exhibit
It is.
2.
I do see this. I do see the ledger. Ma'am, have you reviewed this ledger that was submitted with the brief in this case?
Yes, recently they sent it through. Yes. The ledger, and I have every statement from Woodcrest. And it soars on here, water, trash, every month you have to pay that. So for them to say from June, that would mean I would be really backed up from June all the way to December. There's a base fee on each statement.
I see that. Yes, a water charge and a water base charge and a sewer charge and a sewer base charge.
And if I may if you look at the last page of the ledger, under the date of November 7th, 2018, it gets you to that $1,307.33 figure.
Thank you. So I'm looking at October the 4th of 2018. On October the 4th of 2018, it showed she had a zero balance owing at that time. And then fees were added. Administrative fees, trash fees, water charge, water base charge, sewer base charge, a risk management fee, and then rent.
Yeah, and those charges are from June to July, it looks like.
I see.
And it looks like, according to the ledger, as you pointed out, Your Honor, on October 4th, 2018, there was a zero balance. And if you look at the charges, they all indicate, all the utility charges I'm referring to, they all make reference from May 5, 2018 to June 4 of 2018. What I don't see, Your Honor, which I'm just trying to be forthright, is, well, I guess I do see it. I was going to say, I don't see the charges for the utilities from July 4th through the end of the year. But if you look down back in November, on November 7th, they show charges for 122 days. So they're recouping that period of time.
Yes, I do see that.
Yeah. I mean, what I would propose to the defendant is that we could possibly work out either one, a conditional dismissal, if we can agree upon terms. I mean, we're not looking to hurt the defendant. I'm looking for a way to try to make this as palatable to her as possible.
Would you like to go into a breakout room to see if you guys can work something out? Because she's acknowledging she owes some monies, and you are acknowledging that you are not trying to completely, make her life miserable. So maybe there's some middle ground there. I can't say. I can put you in a breakout session together and discuss.
I would be happy to talk to her. I'll explain to her what a conditional dismissal
I'll
is.
explain that before you leave so she can have.
Well, yes, I plan to do that. I'm pretty forthwith and straightforward. I don't want to.
Well, ma'am, what he's talking about is a conditional order of dismissal, whereby if you enter into an agreement with him about terms of repayment and an amount that you can agree on to pay back, then what happens is it's conditional, meaning that the case gets dismissed as long as you do what you say you're going to do. If you don't do what you say you're going to do, then he comes back here and he gets a judgment from this court against you. A judgment is not a good thing to have on your record, because then it affects your credit in a really bad way. So he's trying to give you an opportunity to resolve this without having, your credit history and everything else affected. You want to go in the room and talk to him about that, Ms. Gordon?
I'll speak with him. Yes, ma'am.
Thank you. I'll put you in
Thank
a room so you can talk. And I'm going to be in another court hearing when you come back. So just give me a moment. I'll take a break as soon as I can to readdress you both. of you.
Okay, just so you know, Your Honor, I have 2 more hearings at 3:30 in another court, so
No,
I'm trying to make it as quick as
all right.
possible.
And I will try to, well, mine starts at 3, so I'll try to come back to you so you can get to your other court by 3:30. Okay?
Okay,
All right,
thank you.
all right. You're gonna get a blue button. Oh, everybody got it. All right, back on the record. In the JGA Acquisitions Inc. versus Trinita Gordon matter, 21C0582, Counselor and Ms. Gordon, were you able to reach any resolution?
Unfortunately,
The amount, you can go.
unfortunately, the parties were not able to reach a resolution on the how much would be acceptable to make monthly payments.
All right,
So I would ask the court if they're just grant our motion for summary disposition, and we'll.
Your Honor, can I say something?
yes, ma'am.
When we originally went into the breakout room, he said, well, you know, he explained again what the conditional meant. And then he said, well, I want to come up with something that was good for both of us. And he said, well, I don't want you to tell me that you can pay this, and you can't, because if you can't, then there will be a judgment immediately placed. I gave him an amount previously, just like the last time. Someone from his firm had already agreed to this amount on several occasions through email once. And it's now, well, it's going to take so many years to pay this amount. Now, I explained to him financially, I'm not in a great place. And that doesn't mean that next year I might be in a better place. The point of me being here and taking responsibility is for me doing just that. I'm taking accountability for that. There is some type of money owed. But I'm not going to admit to an amount that I financially can't afford right now.
You understand what the alternative is, Ms. Gordon?
Yes.
Are you sure?
Yep. There's a judgment.
And then
there's going to be placed.
And then if they get to garnish your wages, and then they get to attach to your bank accounts.
I'm uncollectible. I tried to explain it to him. I don't have any accounts. I'm not in a good place financially. So, I mean, I don't know. I'm not, you know, going around it or anything. I'm being honest. So.
And you understand that this judgment, I believe it lasts for 10 years, and then they can come back and renew, and they keep renewing for the rest of your life. Okay.
It won't last that long.
It will affect your credit.
But yeah.
All right. I'm going to grant the plaintiff's motion for summary disposition in this specific case. Mr. Statfield, I'm granting the motion for summary disposition. I'm not necessarily granting the motion as to the amount. I don't believe that there's a material issue of genuine fact with respect to what happened in this case. The question is, in my mind, whether there's a duty to mitigate for the month of December. So was there something that was done to try to relet this apartment?
I honestly do not know. I can ask my client and tender to the court an affidavit indicating what actions they took to re-rent the apartment in December. Even though before the court, she's admitted through the request for admissions December's rent.
I understand that she admits that she hasn't paid it. I'm very clear on that. You still have a duty to mitigate your damages.
Right, I understand that.
Mm-hmm.
If you want, we can tender to the court an affidavit after we speak to our client as to what transpired, and then you can rule on the money portion if that pleases the court.
That does.
Okay.
that.
I'd be happy to provide that to you and to the defendant.
All right, thank you.
Thank you.
We'll try to provide that within 30 days, Your Honor.
That's fine. What I'll do is I'll just bring you back to make sure that we don't lose track of the case and that everything is managed. Okay?
Okay.
So I'll bring you back here. About 30 days. No, we need longer than that. September 2nd.
At what time, Your Honor?
Let me see. Just do it at 3 p.m.
Okay.
Oh, wait 1 second. My recorder told me to hold on.
Okay.
Oh, okay, let's just make that 2:30.
Okay, that's fine.
Thank you.
I'm presuming,
Your Honor.
I'm presuming, Your Honor, that if we supplied this affidavit to your satisfaction, that you'll rule before that time and there won't be a need for a hearing?
As long as it comes before me, as long as they bring it in to me for me to review it, that's
Yeah.
correct. Yes. All right. Thank you.
Is
So
that-
I want to be very clear in your document that you file. Okay.
I will try to be.
Thank you.
It was nice to see you again, Your Honor.
Thank you. Nice to see you both.